Matter of Rawlins versus Teachers Retirement System.
Your Honors, may it please the Court, Chet Lukaszewski for Petitioner Appellant Rawlins. I would like to request 4 minutes of rebuttal, Your Honor.
4?
Yes, please.
Yes.
Thank you. Your Honors, the Medical Board used the term purposeful conduct. The Supreme Court used the term intentional harassment or assault. The Appellate Division used the terminology purposeful conduct. That is the issue. This Court made very clear in Walsh it hadn't decided the issue. The language of Walsh seemed to leave the possibility, seemed to leave the probability even, that there would be a circumstance or circumstances where probable conduct fit the accident criteria. Why would it not? Why would the probable conduct, and I don't want to use hyperbole, and I really did strain at the end of my brief to give examples.
But in this particular case, we're not just talking about one incident, right?
My client has said that was the moment in time. Her doctor has said that was the moment in time.
This person repeatedly was seeking her out, correct?
This person, until the 18th, until the disabling moment in time, was not known to my client to be a danger, to be a threat. The other...
But he was seeking her out, having interaction with her. But you're saying the triggering event was the last one, not the preceding ones.
I don't know when this person's obsession or stalking or whatever term we might want to use turned to my client. In the initial interactions, which were mundane, which were part of the normal expected job duties, she had very little dealings. There was very little specificity. He came, he was given a letter by someone else. As the principal,
Was it a part of her duties to interact with him?
No. He was in a different branch. But as the principal, she is the overseer of the building. So...
Yet it's not her responsibility to deal with him, you're
No.
suggesting, in spite of her being responsible for the overall building.
In general, daily dealings, as she said, she might say hello in passing. It was a school cook. She was the principal.
But as to the environment of the school, and if things are impacting the school, is it her responsibility to make sure he is removed, or if he has an issue, that it is taken care of?
This is bureaucracy. She's the captain of the ship, but she doesn't have the power in that branch, in the utilities branch, to terminate somebody. She's in the educational
Could
side.
she remove him? Could she have removed him from the
No,
building?
that's why she had to send so many emails. That's why she had to bring so many other people into the fold to have him removed. That's why it wasn't her.
But she had to take some action,
She had to make requests. She had to say, I'm getting complaints.
but so she had to do something.
Yes.
And you're saying yet that is not a part of work? That doesn't then cause her this not to be an accident?
No, that is all part of work. Those are the activities that are the normal and mundane and non-personalized and non-criminal and non-putting her...
That's not what your client said. I think she said her job was to securing safety. So wouldn't this scenario fit directly into that?
I think the hundreds of other examples she admitted to dealing with where it was a normally distraught employee, it was an upset parent, it was an upset vendor. Hundreds of those in her career, no problem. She is full duty, no psychological issues.
What exactly does the record show that he did that makes this different from, you know, a disgruntled employee or a distraught parent? What exactly would you point us
The
to?
personalization after the other events, which I can only use the terminology information gathering, perhaps. At that moment in time, she realized these other events, which were mundane at the time, which had no psychological impact, which had no damaging effect.
But how is it different than a parent who may perceive her as having authority to do something that the parent wants and goes to her perhaps repeatedly in an effort to secure some, change in whatever practice is happening at the school, or a disgruntled employee for that matter?
Sure. Well, Your Honor, if the parent starts yelling, "This person has my belt and wallet, this person has my belt and wallet," and is trying to push his way through security guards to get direct access to this person who has to respond to the scene as part of her job duties, that is what made her think, oh, he's been removed already. We've cleaned out his locker.
I guess
He's
that's
turned-"
what I'm grappling with, though. I mean, as Judge Singh said, she described her own role as securing the safety of the school. And so why isn't that interaction part of that responsibility?
Because this took it to another level. This became personalized. This put her in threat for her
But
life.
a parent could have done the same thing is the point, right? And that would have been part of her responsibility?
If a parent had personalized the situation, I think yes.
And would we call that an accident, even though that's sort of within her responsibility to deal with irate parents?
I think that's the level we're trying to determine here. How far does it go? How much is someone in that position expected to endure? When she all of a sudden comes to the realization, this person might have delusions
Well,
about
it's
me.
not quite how much they're expected to endure. It's whether it ought to be ordinary disability retirement or accidental. And the question then is whether this is characterized as an accident.
Well, that end, can a purposeful act be an accident, which we're hopeful in the overall scheme of this case it can, and then does this fit the
Well, you
criteria?
might win that proposition and still lose the case.
I hope that would not be the case. Again, I don't want to lose sight that there is two prongs here, and I absolutely am advocating for my client.
But doesn't it have to not be a risk of the work performed?
Yes.
Okay, and so what I'm grappling with is, why is, just like with a parent, if there is someone who is disgruntled, unhappy, angry, and she's responsible for securing the safety and running the school, why is interacting with that person, as unpleasant as that might be and maybe scary, why is that not a risk of her particular job as she's defined it?
I think to a point it is, and then I think there are extreme examples, and this is the extreme example. I think if a counselor appears before a judge a certain amount of times, and maybe they have to be escorted out. The time they start charging to the bench and saying, "You have my wallet, you have my keys, you have my cell phone, I want to see you, I know you." We all have now homes that we own, we have families. Everything that she listed that went through her mind, this is now beyond my job. This
Counsel,
has become
can we
about
talk
me.
about that evidence just a little bit? Because I think in this incident, the last one anyway, there was no personal interaction between them. She was in a different location, and he was trying to get through school security.
He was demanding to see her, insisting in a violent and aggressive manner.
So did she hear any of that? Does the
Yes,
rec-
she was
heard it?
just feet away. It was almost as if Your Honors were behind that door and the individual was trying to get through that door, knowing where she was. That's the point of the employment aspect of this. As a principal, she has to report to school every day. She has to leave school every day. She has to go to the parking lot where her car is every day. If there's a disturbance, she will have to go there.
Do you think this record establishes that he actually intended to do some injury to her?
I think the New York City Criminal Court has verified how much of a danger that he was found to be to her. The order of protection shows that this isn't us hypothesizing. This is a criminal court judge agreeing that these facts with this individual, it is a personalized danger. Hence the order of protection, which was in the record, which was known about. I mean, this person has gone through, we've talked about this, many stressful occurrences. This retirement system medical board very rarely will find an event that happens in the workplace to create a permanent psychological disability. Both of those things happened on this day, in this time, and then the New York Criminal Court said, we agree, this person is such a danger to you. I am just hoping that the court will see that there are events, there are purposeful acts that can go above and beyond what someone is expected to endure in their job duties. We think this fits that criteria. We also, again, would just like to remind the court that this is not if purposeful acts within the scope of job duties that are so heinous and so extreme. Thankfully, they don't happen all the time, but they do happen. The retirement systems are not going to go broke. This will be protecting the few, not hurting the many. When this does happen, when the scenarios that I put in the hypotheticals in my paper do happen, people who enter civil service, whether it be a nurse, a parks worker, a court officer, a police officer, the few who have the misfortune of being permanently disabled for life should gain the benefit of these pensions. And again, if it's not an accident, if someone has under 10 years, there's nothing. They get their contributions back, they go about their life with their contributions with a permanent disability. They could be 30 years old, they could be 25 years old. If these acts are not deemed to be accidents, it is going to leave the very few out there who are very unfortunate in their job duties, that the extreme event happens to them, it's going to leave them destitute. Come back on rebuttal.
Good afternoon, Your Honors. May it please the Court, Janet Zalian for TRS. Mr. A, the former school food service worker, wanted to see the principal. He always, in all these incidents, wanted to see the principal. He thought she could get his job back. He was wrong. She doesn't hire these people. But since she is the principal, she's the point person that people are often going to look to when they have a dispute about something in the school. And in addition, as she
So
herself...
are you arguing that it was in fact a part of her job to respond to his complaints and interact with people even though they may in fact be disgruntled?
That is in fact what the position involves. And remember, this is a bargain for position. She did not remain a rank and file teacher. She wanted to be the point person to, as she says, to secure safety in this building and to deal with emergencies. So,
About the argument that there may be behavior that gets to such a level, she shouldn't have to deal with that.
well, first of all, as I think you noted in the questioning that was brought up, she didn't hear this particular remark. It was reported to her later by a school safety officer, but because she was behind the lunchroom doors, she is not in his presence, and we don't know what he meant, because there was this instance where he came and also he cleaned out his locker. We don't know if he lost that property and he wants, and he mistakenly thinks that
Counsel,
she has it.
I know we've gone down the second part of the path, the scope of employment, but where do you stand on the rule that was applied by the appellate division, the purposeful conduct rule?
Well, the appellate division said two things. As in prior cases from the first department, it said that purposeful conduct doesn't constitute an accident, and it also quoted this court's definition in Kelly that a precipitating event that is not in the risks of the job would be an accident. So as in the cases in Walsh, for instance, where the court said we don't need to employ to decide here whether in some instance a third party's intentional conduct might be an accident, this court doesn't need to do that here, and this court doesn't need to set out a bright line rule in either direction with regard to...
You're saying we should keep the question open?
Well, you certainly should keep the question open here, whether intentional conduct could ever, in some circumstances, be an accident, because I think it may have been Judge Wilson who at the end was saying, or Judge Garcia, that in this case, if the petitioner won the proposition that intentional conduct could ever be an accident, it would be lost on the actual facts here, where there is no, where it is not.
Well, that gets me to another question about the actual facts. There was, because there was an application of the purposeful conduct rule, both at the board or at the agency level, as well as at the appellate division, there's never really been a finding about those other factors that we look to determine whether or not it was an accident. So are we to now search the record ourselves and draw our own conclusions about whether this was accidental or not?
Well, first of all, there is, the source in the record is her own admission that both by her own statements in her application for benefits, where she says that her duties were to secure safety in the school and deal with emergencies, and also in the course of conduct of all of the work that she did in response to the various incidents, like filing occurrence reports. And
That's back to within the scope of work. That's not
Right,
on whether,
it's
that's
in
not
the
on whether
scope
this
of
is an
work.
accident or not.
right.
And
but
Judge
the-
Kaneshiro, I think, was asking you about whether this is an accident or not.
Well, what I'm saying is it's not necessary to search the record in terms of what the basis for finding that, of this court's full definition of what an accident is. And in fact, in the Walsh case, this court.
No, but counsel, my concern is no one below has said this was an accident or this wasn't an accident because of the application of the rule that effectively says it can't be an accident because it was purposeful conduct, which, you know, we, as the chief said, we may very well disagree with that proposition.
But the determination under review is whether it falls within the meaning of an accident. And when you want to apply that definition, you apply the definition that this court has developed through case law.
And
So
is
the
that
question-
because we're bound by what the medical board decided below, the parameters at the medical board? Are we bound by those?
We're not bound, you're not bound by it in the sense that they didn't render a case law definition, because they're not lawyers, of exactly what the elements of the problem with it being an accident with purposeful conduct here. What the issue, because even if you wanted to say that purposeful conduct might in some circumstances qualify, it would not under the test here, because the test is the same record that was before the medical board.
So
If
I
the
think if
court-
I could just cut to it, if we don't agree with the standard that was applied below, we can make our own determination applying the correct, what we view as the correct standard.
Yes, and in fact, in the Walsh case, the court noted that you didn't reach the intentional conduct prong, because the court said that that obviously this personal assault was not within the scope of employment. That actually was not the ground that was discussed below. That was a ground that was the medical board in that case and the courts below had said that it wasn't, that purposeful conduct doesn't qualify.
Counsel, just a factual question raised by your adversary. My understanding here was that this person was awarded ordinary disability benefits.
Correct.
This isn't a case where there's less than 10 years and they don't have any recovery.
Correct. The 10 years is not relevant here. There may be a fact pattern in some time where the person, the petitioner in such a case would be left without a remedy, and this court may then address it. But it is not an issue here. In this case,
It is just that one benefit is more generous than the other.
one benefit is more generous than the other. But since there has to be a standard, and this court has developed one over the years, that it has to be an event not within the risks of the job. This is definitely within the risks of the job. Does the court have any further questions? Thank you, Your Honors. We'll ask that you affirm.
Thank you.
Your Honors,
Can I just ask you a factual question?
Sure.
It looks to me from the record that I see your client's characterization of the incident on the day in question, the one you referred to as the last one, at page 41 and 147. Is there any other place, which is her letter and also her contemporaneous statement at the time? Is there any other place I should look for to see how she describes it other than those two documents?
No, Your Honor. She also discusses it during the medical board exams, but those are the synopsis that we would refer to.
Thank you.
Your Honors, the TRS chooses to allow their medical board to make the accident incident determinations. We were given the explanation. It's unlike the fire department, which has a board of trustees, the New York City Employees Retirement System, the NYPD pension fund. They can't now hide behind that we didn't cite case law because we're not attorneys. This is their handling process. They allowed the medical board to set forth the reason for denial. Their reason for denial was that this was purposeful conduct. The Supreme Court then referenced assault and harassment cases. The appellate division then said purposeful conduct.
So I'll
If-
ask you the same question I asked your adversary. What are we to do if we take purposeful conduct out of the equation? We hold that sometimes purposeful acts can be accidental. Where do we go from there with the record as it stands?
Then this court would have the authority to decide if, with the purposeful conduct being included in the accident statute, does this fit the accidental criteria? And I think our arguments, which were discussed at length in my initial presentation, and which I think in the dissent in Walsh, and in my examples, I hope have been brought to light that there are extreme examples where people who enter civil service, which gives you a glass ceiling on your earnings, which gives you certain restrictions on what you can and can't do, which means you're contributing to a pension fund and not putting that money somewhere else. In these extreme examples, they're looking to be protected, whether it be an EMT, whether it be a nurse, whether it be someone who cleans the benches. Civil service workers and municipal workers are looking to be protected by these pension laws. If these purposeful events aren't accidents, if these extreme events aren't accidents, then the unfortunate few who are left forever disabled by them are going to have their financial futures destroyed also. We think that they should be protected. We don't think this is going to open any type of floodgate, and we hope the court will agree.
Thank you.